Hey, what's up everybody? This is Tarafdar back with a brand new video. So I'm going to be talking about a couple of things today. I know it's been a while, I haven't been on YouTube, so I just wanted to give you guys a shout out and of course bring you some knowledge that I'd like to share. So let's begin by talking about collection accounts, right? Collection accounts and why it's necessary for you to be careful on listening to other people's advice. A lot of individuals out there on YouTube, particularly on some of the channels that I've seen, are saying, hey, look, guys, don't pay collection accounts. You don't have to pay them. You don't have to do any of that. Yes, and to a certain degree, it is correct. It is not the original creditor. They don't report properly. And of course, there's a lot of erroneous items in your credit report because of a collection agency. But end result is you should still be careful on when you say you don't want to pay them, or you're not going to be paying them. Because here's the thing, right? A customer who's not going to pay a collection agency, they're going to have to go through a couple of cycles. The first thing is, that collection agency can actually report with another name, and they can basically sell their debt to another company, and just so on and so forth. And it's just going to be an endless, vicious cycle of reporting erroneous and misleading information on your reports. Of course, you can always dispute, you can always file the paperwork, send the debt validation, and do all that good stuff. But end result is, if ever, for example, they take the first right of action, and what I mean by that is if they sue you and you have to go to court, or if you have to fight it, you have to contest it, it's going to cost you a whole lot more money than, it's not. So here's an example. Let's say you listen to some people's advice out there. They say, hey guys, don't pay this collection item, and you stop paying, or you just basically don't ever make a payment. Some of the times what happened is they can essentially sue you. They can, go behind your back and they say, look, these people told me to stop communicating with them. And then end result is, they can sue you in court, and there's a date. And if you're in court, or if you're not in court, but they take you to court, they don't notify you of that. And they say, the judge says, hey, how come, where's the client? How come he's not here? The collection agency basically can say, look, the client told us not to communicate, and we're just, filing a suit against him. In fact, here's the charges, and here's why we're going after them. Now what's going to happen? There's a default judgment, right? Default summary judgment that happened against you, and now these collection agencies can come after you. So is it right to say, cease and desist, don't communicate with me, I'm not going to pay my debt, you're not the original creditor, while you know for a fact, okay, that you actually owe that debt, but it's been transferred to a collection agency? You have to be careful, right? What are you asking for exactly? You're asking for a whole lot of trouble. These so-called experts out there who are sharing this knowledge with you and saying, like, don't pay these debt collectors, that's fine. But how are you going about not paying them? What kind of processes and procedures are you putting into place to protect yourself from actually, saying, I don't want you to communicate with me, do a cease and desist, and then behind your back, there's a judgment that's happening. And all this while you told them not to communicate with you, you clearly are enabling that kind of judgment to happen against you, right? You're enabling that process. So there's a whole lot of set of laws outside the FDCPA, which in turn is the Fair Debt Collection Practices Act, that you have to know. Okay, there's a whole lot of other laws past that, like, statute of limitations to, let's say, even the original creditors, the furnisher rules and compliance, and all these things. And when that happens, right, you don't hear these other so-called experts talking about those issues. You don't hear the case laws or things that are happening naturally to customers who are struggling out there, because they don't take the time and effort to do that. They're just bluntly taking information. They saw some forum or information from some other website and just calling themselves these experts. So you have to be careful. Okay, you have to be careful. So when it comes to debt collection, don't say I'm not going to pay, or I won't pay them. By the way, I'm not endorsing any debt collection activities. I feel that they're pretty bad. But what I'm saying is how to stop yourself from landing in trouble. Okay, particularly when you say that, oh, I'm not going to pay these guys anymore. Excuse me. Particularly on those scenarios, particularly on those circumstances, under what context are you saying that? So you have to do the right thing. You have to validate that debt the proper way. You have to pick up the phone and you have to tell these debt collection agencies, hey, look, I'm willing to listen. However, I need you to validate this information. I need you to cease communicating with me via phone. However, everything should be sent in writing. Make it very clear, okay? And say, whatever you say that I owe, I need it validated appropriately. Upon that, we will confirm whether or not it is something that I should be liable for. Don't ever say I'm not going to pay. Okay, don't ever say I want you to cease and desist communication at all costs. When you say cease communication and you said a debt validation, because of your initial request of communication on ceasing that, they can actually not verify it at all, because they could want, if they want to, but because you told them to cease communication with you, they can simply stop, because now it becomes like a bipolar communication issue, right? Like first you say don't communicate, and then you said a debt validation and you want them to communicate back with you. So you have to be very clear on what you want. Don't take interpretations or advices from individuals who have no sense of pedigree of dealing with debt collection activities, particularly on that side of law. And I believe that you have to kind of like take it at a very, very small level, that practical advice that they're sharing with you, the so-called experts, right? So when it comes to debt collectors, I think what you really need to focus on is really communicating with them in reference to the appropriate way of validating that debt, the appropriate way of saving yourself from trouble, the appropriate way of analyzing whether or not you actually legitimately owe them. And from that angle, from that direction, then you can make the choice of whether or not you want to pay or not, depending on how the debt validation was done, depending on the compliance. There's so many different rules, even for the fact that they're reporting on your credit report. There are rules for that. So you have to tackle it on those angles, not saying, look, I don't want to pay you anymore. I want you to cease communication, cease and desist. And all of a sudden you got a default summary judgment against you and you don't even know it, right? And then they can come and take a lien on your property or garnish your wages. This is how it happens. All this stuff happens like that. So yes, typically when they say that without any real substance, that I'm going to garnish your wages or we'll put a lien on your property and stuff like that, that's false, right? So that's misleading tactics. Of course, it's a violation of the FDCPA. But when you tell them, like, look, I don't want you to communicate with me, I want you to cease communication, I want you to do all that stuff, you're actually now putting yourself in more trouble. So you got to be careful in what you're asking for. And you don't listen to advice that's not practical. So you have to go through debt validation. That's a must, right? Past that point, make sure that everything's accounted for. Make sure that you have the statements properly. Make sure that you can verify everything as needed. Look at the erroneous item on the report, and tackle it from that angle. Okay, and just work it that way. Secure yourself prior to following any type of advice out there that's saying don't pay these debt collectors. Okay, there's a lot more to it than that. There's a lot more legalities to it than that. There's courts that have ruled things in the past couple of years that kind of favor debt collectors in a sense that, and particularly in electronic reporting, that they don't need contracts, they don't need a couple of things that even furnishers who are putting erroneous items on your report, signed documents, all this Section 609 thing going around that's been around 1989. If it was 20, 30 years ago, it's not anything unique. What you got to work on is the legalities, the compliance aspect of everything that's happening, and then tackle it from there. Sounds good? So I hope this video was helpful. I don't mean to be harsh. I just want you guys to wake up to the reality of things and wake up to the advice that you're listening out there. I'll be shooting out a couple more videos in the next couple of days to help you guys come into more clarity in reference to credit repair, particularly on that side with collectors, with medical bills, with erroneous items, with bankruptcies, public records, all that good stuff. Okay, so this is Ali Tarafdar, your guide and mentor. Bye for now.